Hello everyone and welcome to today's Mondac webinar in association with McCarthy Tétrault, discussing the most important new issues in Canadian employment law for 2023. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Before I hand you over to Tim Lawson, a partner in Toronto and the National Practice Group Leader of McCarthy Tétrault's Labour and Employment Group, to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and the panel will endeavour to answer as many of your questions as possible. It's now my pleasure to hand you over to Tim to begin. Thank you.
Thank you, Dan, and thank you everyone for joining this webinar. We're from the law firm of McCarthy Tétrault, which is a Canadian national law firm. We have a large labor and employment group with offices across the country, and we deal with many Canadian and international North American employers in labor matters, employment matters, pension matters, immigration matters, sort of full service. So that's my shameless plug for the moment. Go on our website. We do have a lot of material content on our website about recent developments in Canadian employment labor law, including a cross-border book which looks at Canadian employment law for those who don't necessarily practice or aren't HR practitioners in Canada. So if you're from the US or international countries, look at our book. Download it. It's free. We think it's pretty good. But enough about that. What's this session about? We thought we would partner with Mondac and give you a sort of a summary of some of the really key employment issues that we deal with on a daily basis, which are causing our clients to have concerns going forward in 2023. So we've got 4 topics for you today, and Pat Pengelly will be talking about the new Competition Act changes, which is quasi-criminal legislation, very concerning, dealing with no solicitation and wage fixing. So we'll talk a bit about that. Jess Woogler will talk about termination issues in Canada, which are very topical. We obviously deal with them every day, and we're a very generous jurisdiction in Canada in respect of termination issues. So hold tight for that. Emily Thibault from our Quebec office will talk about the French language changes under various legislation in Quebec, again, for employers that are doing business in Quebec, and Quebec represents about 1/3 of the country in terms of the economic output. It's very topical issue, and lots of obligations for employers. So we'll hear about that. Emily will give the presentation in English, thankfully for most of us. And Marco Fimiani at the far end of the table here will talk about remote work and hybrid workplaces, which is obviously an issue across the globe, but we're going to dive a little bit deeper into the Canadian implications of that, looking at some of the legislation that's applicable to give you a flavor of what obligations you may have as an employer and really what's trending currently. So that's the outline. So 4 topics, and as Dan said, we'll try and take some questions. You can put your questions in on the question panel. I'll get them, I'll look at them, maybe I'll curate them, we'll see. And I'll pose them to the panelists probably near the last 15 minutes of the hour that we have, maybe intermixed depending on whether I can read them and whether I can organize them in my head to offer them to the panelists. So that being said, I am going to pass the baton over to Pat Pengelly, and we'll talk competition law for a couple minutes here.
Thanks very much, Tim. Good morning, everybody. And as Tim mentioned, I will be speaking with you this morning about new amendments to Section 45 of the Competition Act, which come into force next month, actually, on June 23rd, and specifically the relevance of these changes for employers. So if we could move to the next slide, that'd be great. Great. For those of you that don't know, Section 45 of the Competition Act deals with offenses in relation to competition and the related penalties in connection with these offenses. And by way of background, these new offenses follow similar trends in the US. Interestingly, the amendments are also similar to recent trends in employment law, such as the relatively recent prohibition on non-compete agreements for non-C-suite employees in Ontario. So why are these amendments relevant for employers? The answer is that as of June 23rd, as Tim mentioned, it will be a criminal offense for unaffiliated employers to enter into wage fixing or no poach agreements. So I'll expand a little bit on what these prohibited agreements are. Wage fixing agreements mean agreements to fix, maintain, decrease, or control salaries, wages, or terms and conditions of employment. So this is a pretty broad definition. According to the draft government guidelines that we've been provided, and again, these are currently draft guidelines, this can include anything from job descriptions to working hours. So again, terms and conditions of employment, pretty broad definition. No poach agreements mean agreements to not solicit or hire each other's employees. And the draft guidelines state that all forms of agreement between employers that limit opportunities for their employers to be hired by each other are prohibited under the Act. Examples of prohibited restrictions also include restricting the communication of information related to job openings. So, and again, that's according to the draft guidelines. So again, pretty broad definition here. Of note, as a result of the amendments, a violation of Section 45 may result in personal or corporate fines, and importantly, the former $25 million cap will be removed as of June 23rd. So, and penalties can also include jail time of up to 14 years. So very serious potential consequences here. And as you can imagine, this has definitely caught the attention of employers. And we've been getting questions from our clients on a regular basis about this new legislation and its potential impact on the workplace. So what I'd like to do over the next few minutes or so is discuss at a high level the current commentary, some potential issues, and relevant considerations for employers to think about at this early stage. So with that, I think we could move to the next slide. Thank you. Great. So importantly, the Act also contains statutory defenses and exemptions which are relevant to employers. First, the new offenses do not apply to agreements between affiliated entities, so such as parent and subsidiary companies. So affiliated entities are an exception. It is also a defense under the Act where a party can establish that the wage fixing or no poach agreement is ancillary to a broader legitimate agreement between parties, and the wage fixing or no poach provision is related to and reasonably necessary to give effect to that legitimate broader agreement. So briefly, here are a couple of examples from the draft guidelines that are relevant for employers to consider in terms of potentially defensible agreements. An example of a potentially defensible no poach agreement that is common to many employers is a no poaching or non-solicitation agreement entered into by two employers to, for example, prevent Company A's employees from being hired away by Company B while Company A's employees are seconded at Company B. This type of one-way restriction or restraint only applies to employees, so it may be defensible. Another common example is a no poach agreement between a staffing agency and its client not to hire each other's employees while the staffing agreement is in effect. This may be a violation of the Act, and as an aside, it may be also in breach of employment standards legislation, depending on the province that you're working in. But according to the draft guidelines, in order to be defensible, the companies must first demonstrate that one, the no poaching agreement flows from the broader staffing agreement between the two entities, and second, that is directly related to and reasonably necessary for achieving the objective of the broader staffing agreement. And factors that the Competition Bureau may consider when they're looking at whether or not this restraint is reasonable is whether less restrictive means were reasonably available to the parties, the duration of the restraint, the scope of the restraint. So, these factors are, of course, similar to the factors that are looked at when assessing restrictive covenants in the employment context. So sort of familiar grounds here for the employment lawyers in the room. Also, according to the draft guidelines, when an employer acts independently, but is aware of the likely response of a competitor or acts in response to the conduct of a competitor, it is not a violation of the Act. The guidelines call this conscious parallelism, which frankly is a bit of a mouthful, and I think it's clear that employment lawyers didn't draft these guidelines. But that said, even when an employer acts independently, if the parties engage in any practice designed to facilitate parallel conduct, for example, sharing sensitive employment information or monitoring each other's employment practices, this may be considered a violation of the Act. So accordingly, I think that the thing to note here is that employers should be cautious when sharing information about wages and salaries and so on during any industry-related collaborative activity. And finally, it's worth noting that there is a general exemption under the Act for collective bargaining activity between multiple employers in a trade, industry, or profession with their employees. And with that, we could move to the next slide, please. Thanks. Great. So just some takeaways for employers to consider here in light of these new amendments. Something to think about: benchmarking and membership in industry associations are of course common among large employers across various sectors, and such practices may be subject to scrutiny going forward. And we touched on this point a little bit in the last slide. So, a best practice may be to ensure that any information sharing is collected or distributed by neutral third parties, that data is aggregated, anonymized, and historical rather than prospective. Another point is, at this stage with the changes on the horizon, consider doing an HR audit and review any internal arrangements with other unaffiliated parties, such as secondment agreements, services agreements with staffing agencies, and so on, in order to mitigate any potential issues, as well as update company policies to account for the new offenses where applicable. And lastly, in the transactional context, for example, consider whether restrictions, in a purchase agreement concerning a seller's employees are reasonably necessary in scope and duration to protect a buyer's interest. And listen, I know this was a lot of information in about 5 minutes. For context, we did a 2-hour panel with our competition law colleagues on this topic. So I know there's a lot more to unpack, but I'll leave that for now. And with that, I'll turn it over to my colleague, Emily Thibault, who will speak about important legislative changes in Quebec. Over to you, Emily.
Thanks, Pat. Yeah, so my name is Emily, and I practice in our Montreal office, which is located in the province of Quebec. I think before we delve further into the topic of Bill 96 and how it impacted the pre-existing Charter of French language requirements, I think it's important to discuss the fact that approximately 85% of Quebec, more than 8 million people, speak French as their primary language, and Canada has currently approximately 38 million people. Quebec is a leader in R&D, in biotech, aerospace, energy exports, and all this to say, if you are or plan on doing business in Canada, there is a serious possibility that part of your workforce will be based in Quebec. I think we can move to the next slide now. Thank you. Yeah, so the Bill 96 was adopted a little less than a year ago. Some provisions came into force as soon as June 1st, while others will come into force in the next 2 years. It was adopted with the view to further strengthen the French language legal requirements that were already imposed to companies doing business in Quebec since 1977. Also, as a general comment, the bill was adopted in a rush shortly before the inception of the 2022 fall election and clearly had a political aim. And as such, the language in the bill is ambiguous, I will say, and there are few gray areas still that we're monitoring. And another general remark that I would like to bring to your attention is that the bill is also not overly clear as to its scope of application. This being said, there is a strong possibility that if you have a worker domiciled in Quebec and performing work from Quebec, even though you have no place of business of Quebec, the requirements that will be discussed in the presentation likely apply to those workers. So we can move to the next slide, please. Thank you. So as a result of Bill 96, now Quebec workers have a protected right to work in French. And that is really the cornerstone of the bill. Interns and senior executives also enjoy this right. Alternatively, this means that if you are an employer and would like to require the knowledge of another language than French, you will have to meet certain criteria. The criteria are laid out in this slide. They are hard to achieve, and we're monitoring again this situation, and there has been no case law to our understanding that have discussed these new criteria and how it affects the requirement of English as a job requirement. We can move to the next slide. Tied to the right to work in French is also the new requirement that French is the official language of written communications. And so this means that moving forward, employers must communicate all written communications to their employees at least in French. And when I say at least in French, it means that you can still communicate with your employees in English, provided at the same time they can have a French version available. There are, however, two exceptions to this requirement to communicate with your employees in French. The first one is if the communication is not deemed as a contract of adhesion, which means that the conditions of employment were negotiated and not imposed on the employee. This would typically be the case for senior executives. And the second would be if your employee elected to receive communication in English. This consent can be obtained in the context of the onboarding process and not during the negotiation with the candidate. We can move to the next slide, please. So in addition to the individual right to work in French, Bill 96 also lowered the threshold towards the mandatory issuance of the French certificate. This means that starting June 25, employers with 25 employees or more will now be required to seek the issuance of a certificate by the Office québécois de la langue française. This certificate is only issued once the office has determined that French is generally used at all levels of the company. And if French is not used at all levels, the office has the power to order the company to undergo a franchisation program. And this, from experience, is definitely costly in time and energy. We can move to the next slide, please. Thank you. With the same objective of ensuring that French should be the official language in the workplace, the office now has the power to order the forming of a franchisation committee to enterprise employing fewer than 100 persons, which the previous legal requirement was only if there was 100 and more. And as a general comment, a franchisation committee is they have to meet a few times a year, and they are comprised of representatives from the employees and the employers. And there has to be minutes and few other requirements that have to be followed in order to comply with the franchisation committee legal framework. And now if we can move to the next slide, which is consequences for non-compliance. I think that is probably the key question you have at this point in time. Well, specific to written communications, if no French version was made available to the employee upon the signing of the contract, let's say, we would think that the provision will be deemed as unenforceable because it was not executed in French. And there's a possibility if the employee has a high English proficiency that the reduction provided for in the contract can be reduced. Another key aspect to consider is that employees now have a complaint mechanism designed so that if they feel like they were discriminated or harassed because of their knowledge of French or the little knowledge of English, well, they can file a complaint with the CNESSC. And I don't know, and I'm sure for those who are familiar with the CNESSC, but just again to reinforce what it entails, the CNESSC is a governmental body that assists employees challenging several aspects that relate to their employment, and they receive assistance from a lawyer free of charge. So this is something definitely to consider in the risk assessment in the enforcement of the French language requirements. Another key non-compliance issue are the administrative and penal sanctions. As such, if you fail to comply with the legal requirements, you may be ordered penal and final sanctions. I'm also aware that if you, let's say, fail to obtain the franchisation certificate within the specific timeline, there's a possibility that the enterprise will, well, the eligibility of the enterprise to certain tax programs will be affected. And finally, there are also additional fines that can, yes, be imposed to enterprises, but also directly to directors and officers. And yes, thank you for listening. And if this presentation has left you worried or curious, do not hesitate to reach out. Thank you.
Thank you, Emily. There's been a couple of questions.
Sure.
Maybe I'll just throw one out. I'll throw one out right now before we move on to Jessica. So one of the participants has asked about this idea that the OQLF is mandating social media like Pinterest and Instagram that it should be in French first. But if a majority of the customers are in Ontario, what does the company have to do? Can they say, well, the customers are in Ontario, the majority, so I can just do English, or do they have to do English and French, or do they have to do French first before English? Does the font have to be different? What advice would you give in this situation?
Yeah, well, this question is really commercial related, so that those are different provisions would apply, and unfortunately, Tim, I cannot answer to this one. Okay,
great. So we'll, if whoever sent that question, if they can send it to us, we can get an answer for that. So let's pass it on to Jessica.
Thanks, Tim. Today, I'll be chatting with you about terminations without cause, for cause, mass terminations, and the trends that we're seeing. So if we can go to the next slide. So as Tim alluded to at the beginning, Canada is a very expensive jurisdiction in terms of ending the employment relationship. And that arises because of the fact that we have a concept of common law reasonable notice baked into indefinite term employment relationships. So that means that if you want to end the employment relationship without cause, then you're on the hook for what's turning out to be longer and longer notice periods. And one way that employers used to limit that or mitigate the risks associated with that is to come up with and draft very specific and carefully termination clauses. However, we've recently seen quite an attack on the enforceability of these termination provisions. And so there's two cases that we wanted to just touch on today to give you a sense of what we're talking about here. So for example, in the Quesnel and Camus Hydronics Limited 2022 Ontario Superior Court 6156, the court was presented with a termination provision where the employer said it's enforceable. The employee, former employee, is taking the position that it's not enforceable and therefore should be entitled to a longer notice period. Basically, the clause that the parties were fighting over used and or in the clause. So basically, it said you'll be entitled to only the minimum termination pay and or severance pay as required under the Employment Standards Act of Ontario. And while, you know, the employer probably intended that to mean that if the employee met the threshold and the criteria for severance pay, because there's certain criteria that an employee has to meet, that the court looked at that and said it's ambiguous. We can't enforce that. It's not enforceable. If the employee reads that provision, it doesn't clearly let them know what they would be entitled to at the end of their employment when they're terminated without cause. And so, you know, although that what might seem to be, you know, a minor drafting error, the court threw out the termination without cause provision and said that the employee was in fact entitled to common law reasonable notice. So the other case that we wanted to highlight as well is the Tan and Stostick Inc. 2023 decision, where the Ontario Superior Court was faced with another termination provision where, in this case, the termination for cause provision did not provide any notice entitlements upon termination for cause. However, there was a saving provision in the termination without cause that provided that in the event that any of the clauses would be found in violation of the Employment Standards Act, that the greater entitlements under the Employment Standards Act should be incorporated and prevail. However, the court looked at this provision and again attacked it and found that it was not enforceable because of the fact that it created an unclear problem for the fact that if the employee read it, the court said that they wouldn't know that their entitlements, you know, what exactly they would be upon reading the termination provision. They'd have to go to the Employment Standards Act. They'd have to look at all the different provisions and sort it out themselves. So they said again that in this case, the termination clause was not enforceable. And then it basically wiped out, you know, the entire agreement in terms of the without cause, the for cause, the fail-safe provisions. And the employee was entitled to common law reasonable notice, so a longer notice period than what's provided for under the Employment Standards Act. And so what we're seeing, you know, as the pendulum swings in favor of employees is that our common law jurisdictions are starting to look more and more like what we see in Quebec. And Emmy, jump in if you know, you want to add anything, but basically in Quebec, there's minimum requirements that the employer has to provide, but then there's also baked into that the requirement to provide a reasonable notice period or a contractual indemnity that's reasonable in the circumstances. So it sort of lines up with the common law analysis, but it's a statutory requirement. And so, you know, although we don't have the statutory requirement in the common law jurisdictions, because the court's throwing out these termination provisions, really attacking them, we're starting to see, you know, a shift in the common law jurisdictions where we're moving towards the concept where we're always having to look at what, you know, would be reasonable in the circumstances and looking to more so the Bardell factor. So, I mean, I don't know if you wanted to jump in on that point and add anything there.
Well, the only comment perhaps that I could make is that in Quebec, even if you have a contractual provision that could potentially be deemed as reasonable upon the signing of the agreement, the assessment as to whether or not it's reasonable is at the time of termination of employment. And if we assert that it's not reasonable, it will be completely set aside. And that is indeed enshrined in the Civil Code of Quebec.
Great, thanks, Emmy. So just wanted to highlight that for you as well, just given the fact that Quebec is slightly different than the other common law jurisdictions. But again, we're seeing a shift to mirror what's, you know, in Quebec and in the Civil Code, but that comes out of our courts. And the other thing that we wanted to highlight as well in terms of the significant growth in notice awards. So generally speaking, there used to be a concept where common law reasonable notice periods, there was a general understanding based on the case law that the cap of the reasonable notice periods is, you know, 24 months. However, we have seen cases go beyond the 24-month cap, and there's case law to say that the court shouldn't go beyond that 24-month cap except for exceptional circumstances. However, in this Millwood and IBM Canada limited decision in 2023, the court, it was a case where the plaintiff was a 62-year-old managerial employee, had worked for IBM for 38 years. And although he wasn't an executive, he was about one level below the executive team. And so what I think really struck the judge in this particular case is that there was unchallenged evidence that the plaintiff had applied to about 122 jobs, never got a single interview. It was in the context of the COVID-19 pandemic. And the Justice Ramsey looked at all of the evidence before him, before the court, and found that although the notice period, that cap, recognized that there is a 24-month cap, that in the circumstances, this particular plaintiff should be entitled to a 27-month notice period, which is, again, exceeding that 24-month cap that we had historically accepted. Now, the interesting thing about this case is that the court didn't, specifically spell out any exceptional circumstances, but instead rather sort of reiterated the Bardell factors, focusing on the length of service, the employee's age, the mitigation efforts that were unsuccessful. And so it really sort of opens the door to cases that are longer notice periods and potentially exceeding that 24-month cap without pointing to any particular exceptional situations or factors. And finally, on this slide, with respect to the importance of mitigation, again, the employee has the obligation to go out and find alternate employment and to mitigate their damages. However, the onus is on the employer to build that record and be able to show that there were jobs available, that the employee should have been applying to these jobs. And so what is important when we're seeing the increase in the common law length of a notice period is that the employer takes the time to build that record and is able to show that the employee ought to have applied to certain positions, and that if they had, they would have been able to mitigate. So if we can just go to the next slide. We also wanted to touch on just cause, and so the termination for cause. And so we'll just backing up a little bit in terms of the termination provisions on just cause and employment contracts. In 2020, is kind of what started the ball rolling with respect to the Waxdale decision that came out of the Ontario Court of Appeal, which basically took aim and said, if your termination provision for cause doesn't recognize that there's a higher threshold under the Employment Standards Act, and that the employee would be entitled to their minimum entitlements upon termination for cause if the employer is not able to establish that, then it wipes out both the termination for cause and without cause provisions. And so there was a recent case that went back and confirmed that Waxdale is alive and well in Ontario, and basically said that the lower court tried to look at the factors and said, these parties were sophisticated, the plaintiff had legal advice, and the parties, when drafting the employment contract, really tried to avoid contravening the Employment Standards Act. So the court actually found that the termination provision was enforceable. However, that was appealed to in the Ontario Court of Appeal, and the Ontario Court of Appeal said, no, we're going back to the Waxdale principles, and in this case, the termination for cause provision didn't provide for the minimum entitlements under the Employment Standards Act, and therefore, overturned the lower court's decision and said that the termination clauses were not enforceable. So just highlighting that where, the just cause termination provision can wipe out, all termination provisions in employment agreements. In terms of, the position that the employer takes upon termination, really want to be sure when you're terminating employment that if you have a case for cause, that you take that position upon termination. So in this case, Ali and the Council for Advancement of African Canadians in Alberta, 2023, basically the employer tried to turn around once litigation had commenced and say that they actually wanted to recharacterize the termination as a for-cause termination. However, the court said that was not appropriate and that there was no basis for that. The employer didn't come into any additional information to justify that position. And it's just a good case to remind ourselves that when we're deciding to terminate, we take the steps necessary to investigate, build our case, and determine whether or not we terminate for cause or not. And then finally, with respect to, the high bar of just cause, we we've got two cases here where the employer was successful in establishing just cause. So in the first case, Melanchuk and Galaxy Motors, this was a circumstance where the plaintiff was the president of a number of car dealerships. He took his wife out for a $250 dinner and then sought reimbursement from his employer, claiming it was a business meeting with employees. When confronted, he continued to lie. The court found, it gave him multiple opportunities to come clean. He never didn't apologize. And the court actually found that although it was a relatively small amount, that the misconduct went to the very root of the plaintiff's employment relationship. And therefore, because he failed to come clean, he was in a position of authority, responsibility, and trust that the cause was justified in that particular case. The other case that we wanted to highlight for you in terms of just cause is the Park and Costco Wholesale Canada, which is a case where there was an employee that worked for Costco. He was responsible for building a website. There was some disgruntled relationships in the workplace. He was transferred to another department. He ended up deleting the website. The employer said, put it back in place. They got it back online. He then deleted it again and therefore was terminated for cause. In this particular case, it's just helpful to highlight that, the court found that the termination for cause was justified, and that was, likely to be the case when you have circumstances where the employee is engaging in willful misconduct and intentional misdoings. So we can go to the next slide. And finally, with respect to mass termination, so what we're seeing because of the economic shift, we're seeing mass terminations, in Canada and globally, particularly in the tech industry. Marco will touch on the recent proposed legislative changes with respect to Bill 79 and the changes to the definition of establishment in the context of mass termination to deal with remote home offices. So just flagging that, but he'll get into that in a little bit more detail. And then in terms of strategies to limit costs associated with mass terminations, when you're conducting these mass terminations, they can be quite costly. So one thing to keep in mind is to be cognizant of any sort of rolling timelines, making sure you're aware of those, and potentially providing working notice instead of terminating employment and having to pay out the entitlements and dealing with it that way. If we can go to the next slide. And finally, just a couple more key tips to address terminations. And so keeping in mind, treat employees respectfully upon exit to avoid bad faith allegations, strategic and creative without prejudice offers. So, if you're terminating, you provide them with their contractual entitlements, but then provide them with something more in exchange for a release. Providing them with letters of employment to get the ball rolling in terms of mitigation efforts, and reviewing employment contracts and termination provisions on a regular basis. And finally, if we can go to the next slide. This is just an overview with respect to, generally speaking, the different types of reasonable notice length periods for different length of service. And again, all of these would be subject to mitigation, but gives you a good sense of how costly it can be when you're terminating without cause in Canada. I'll turn it over to Marco.
Thanks, Jessica. And so, good morning, everyone. And I guess depending on where you're joining us from, it could be good afternoon. So good afternoon as well. So I'm just going to finish off here with the post-pandemic workplace considerations in a remote and hybrid work environment. And so if we can just move to the next slide. And so on your screen here, you'll see a proposed legislative amendment to Ontario's Employment Standards Act. And really the reason why we're talking about this here is I think it shows, or it serves as an example of why work from home is something that requires proactive management. And it's starting to be outrightly contemplated as part of an employment relationship, insofar as we're even seeing proposed legislation and amendments to current legislation regarding work from home arrangements and flexible work arrangements. So despite it being something that everyone thought was temporary, and for some employers it might be, it really is a part of the world when we start talking about the employment relationship and how that starts to blend into other parts of what we typically might have seen in the confines of an employment relationship. So under Ontario's employment standards legislation, employers are currently eligible for increased notice of termination or pay in lieu of notice of termination for mass terminations. So if 50 or more employees are terminated at an employer's establishment within a 4-week period. And so currently the definition of establishment means a location where the employer carries on business. But in its current form, this Bill 79, which is currently in its second reading, seeks to amend the definition of establishment to include, and I'll just read, a private residence of the employer's employee if the employee performs work in the private residence and the employee does not perform work at any other location where the employer carries on business. So the implications of this amendment would really be that employees working remotely could be included in the count for whether an employer's mass termination obligations will be triggered in Ontario. And I suspect that this might be something that we start to see contemplated in other provinces, and it might be something that's contemplated in other jurisdictions outside of Canada as well. And so we can just move on to the next slide as well. And so just to kind of reiterate that point, that I think work from home, or at least discussions about work from home or flexible work arrangements, are here to stay. I mean, hybrid work currently remains the dominant workplace model. I'm just pointing to a survey from Colliers Canada here in late last year, where they polled more than 350 employers. And they found that 37% have employees working in office full time. And that was up only 4% from 2021. And so we were all thinking that that number would start to dwindle down. We would see full-time in-office presence back up, and work from home or flexible or hybrid work arrangements would dwindle down. But the reality is even after we've come out of the second or third waves, or what I'll call the post-pandemic era, and the later parts of last year and into this year, we're still seeing work arrangements and flexible work arrangements and remote work arrangements as part of the relationship between employers and employees. And frankly, employees are asking for it, and in some cases, candidates are actively seeking out opportunities that allow or permit flexibility with respect to what that working relationship and working arrangement looks like. Just as an example, our federal government just went through negotiations with their federal public sector employees, a number of them, and one of the main demands at the collective bargaining tables in that unionized relationship was for flexible work arrangements, and it was a key stalling point, that kind of a key point of the negotiations that at some point led to a strike. And it was part of a bunch of broader factors, but it was a key driving force of the distance between the parties before they were able to kind of reach a tentative agreement. So we'll just move to the next slide as we break this down a bit further. And so when contemplating a remote work arrangement, companies will really want to ensure that existing policies consider and are also applicable to the working from home arrangement. So whether it be a workplace health and safety policy, privacy policies, technology use policies, all of those, while they might be applicable to a work from home arrangement if they pre-existed when work from home arrangements or flexible arrangements were implemented, they should be reassessed and reviewed to ensure that they actually do actively contemplate what transpires and what the differences and nuances might be in a work from home relationship versus a in-office presence. And so some examples are: consider a policy that clearly outlines expectations for an employee conduct and which provides for the protection of company property and confidential information. Will employees working from home be permitted to print company product at home is just a simple example. And factors like that are pretty important. In addition, employers should also consider what technology related expenses and equipment are eligible for reimbursement, as well as contemplate whether ownership, privacy, and acceptable use expectations of devices. All of that should really clearly be outlined in both for the devices and in the information stored on them. And one thing to be mindful of is as a nuance between some of the provinces. Some provinces in Canada don't actually allow an employer to pass on home expenses onto the employee. So if you require an employee to have something with respect to their work from home relationship, for example, a certain device, that will be something that the employer would have to contemplate and ultimately cost, depending on the province. The other thing is maintaining employee productivity is also a critical component of work generally, but it's something that really needs to be proactively managed and contemplated as to how it's going to be assessed in a work from home or flexible work arrangement. So some things to consider might be mandating a required time frame where all employees are expected to be working and available, requiring employees to track their hours of work and reporting hours of work to their supervisor regularly, maintaining accountability by having supervisors and managers set expectations and vocalize concerns as they perhaps become known, scheduling routine conference calls to maintain that face-to-face presence, or at least to maintain communication channels of the employee's work for the week, offering assistance to ensure that employees feel supported. Again, we're making sure that workplace harassment and violence policies also contemplate the working from home relationship and allow for clear reporting lines if necessary. That also applies in, for example, the cybersecurity breach. There should be clear reporting lines for employees on how they use devices, and if they're working remotely and they feel like a data breach has taken place or potentially has, that they'll be able to kind of know exactly what steps they need to contemplate if they're not directly in the office as well. And then, for example, if an employee is overtime eligible, employers should also be clear about what parameters take place with respect to working hours and their policies for overtime work. And this becomes it's a bit easier to contemplate and to manage within a in-office presence, but in the working from home relationship, it's something to really consider, and the lines become a bit more blurred. So for example, if the pre-approval is required for overtime, that's something to consider. But one thing to note is that's generally not sufficient. And so employers will actually need to actively monitor employee working hours to ensure that employees are staying within the boundaries of their working time, and that there's no condonation on the part of the employer of unapproved overtime. And this, in the same general policy of basically actively managing the employment relationship with respect to flexible work arrangements and remote work, really does apply to rest periods, meal breaks, maximum hours of work, vacation, holiday pay, all of that. And so something to be mindful of as well. And we can just move to the next slide. And so some other more broad considerations to contemplate when we look at the remote work policies or arrangements. Human rights. So what's the basis for the request to work remotely or for the flexible work arrangement? It may be rooted in, for example, a family status accommodation request due to childcare obligations. During the pandemic, we were observing some individuals who were immunocompromised, and they were making work from home accommodation requests based on their medical condition and disability. And in workplaces where the relationship is currently a hybrid one, where the majority of the workforce or some in the workforce are currently able to work a bit in office and a bit at home, employers will need to consider whether or not they can actually, whether or not the undue hardship threshold will be met if an employee makes a request for remote work. And in a workplace where there's a bit more of a hybrid working relationship already, in some ways the employer might be actually providing a bit of evidence or a bit of an evidentiary basis to support that they can actually approve that accommodation or manage that accommodation in some capacities. So something to be mindful of. Absent a contract that says otherwise, management can compel employees to come into the office. And leaving aside the legality around doing that for a second, I think management will just want to consider some of the employee relations elements associated with that. Is it actually an emergency that would require an employee who's working remotely to come into the office at that point? Is it something that can be really dealt with remotely? Is it something that can be dealt with the next time the employee is in office? And so some of those, what I'll call soft skills, are important in this context as well. And then lastly, I'll just speak to, can employees work from anywhere, or are there restrictions? And this is really the key piece that should be clearly spelled out, because it intersects with all sorts of compliance obligation and requirements, and might ultimately put some obligations on the employer that the employer didn't intend to actually have on their plate. And so, for example, immigration requirements, corporate and personal tax implications. Will an employee working in a different jurisdiction create a permanent establishment for that company? It depends. Payroll compliance requirements, registrations for workers' compensation, and application of jurisdictionally specific employment standards and other legislation. And so, as we heard earlier when my colleague Jessica here was discussing terminations, Canada is, I believe Tim used the word earlier, generous, but I would say Canada is generally, I would say it's expensive. But so too are other regions in the world. And before allowing employees to work anywhere, employers will want to be mindful that depending on where an employee is working from, that may result in the employment standards of that particular jurisdiction applying. And so employers will want to be intentional and or at least mindful about where an employee, if they're working remotely, can work from. Does that mean that they can work from anywhere in the world? Does it mean they can only work from their home, which is also in the jurisdiction within which the employer is operating? And so some of those, taking the steps to proactively consider those questions and those potential points of exposure, risk, obligations, and duties at the forefront of creating that flexible work arrangement will really benefit employers in the long run in terms of managing that relationship as well. And with that, I'll just pass it back to Tim Lawson here.
Great, thanks, Marco. Boy, that's a lot of information from four panelists in a short period of time. We do have some excellent questions, by the way, so I'm gonna kind of curate these questions if I can. I won't do what I just did to Emily, which is ask her a question that's a commercial question, not an employment question again, hopefully, Emily. So I'm going to go right to Pat. And Emily, I'm going to come back to you. So Pat, one of the questions concerns an employer's involvement in wage surveys and whether that has any impact or is it limited by the competition provisions in terms of the wage fixing? Like, are employers who get involved in these surveys going to be charged with wage fixing, and are their HR people going to go to jail?
Right. Yeah, it's a great question because, as I mentioned before, it's a wage survey can be a common thing within an industry association. And membership to these types of associations can be important to a business, right? So these are, of course, very relevant questions, especially given, the broad definition of wage fixing under the Act now. I mean, it's not just wages or salaries; it's actually terms and conditions of employment. But specifically to the salary survey point, that sort of sensitive information sharing certainly could be subject to scrutiny under these new amendments. Given this broad definition. So again, as a best practice, I think employers should ensure that any sort of information sharing is collected or distributed by neutral third parties. That the data is aggregated, that it's anonymized, and so on. And I think that may well mitigate the risk and/or create a defensible position. And I think, and just for context too, I mean, the draft guidelines, there were public consultations that were held in January to March, and the guidelines have not changed since that time. But they may well there may well be further clarity in respect to these draft guidelines going forwards, and certainly wouldn't be surprised if issues such as this may well be addressed.
Right, and these surveys, whether it's wages or just benefit surveys, that's still part of the wage issue covered by the terms and conditions definition in the Competition Act.
Yeah, that's right. It's a big umbrella, so it's a very broad definition.
Okay, Emily, I'm going to ask you something that I'm actually interested in, but someone else asked the question. You know how in employment contracts or documents in Quebec, we have in the past drafted them in English and put at the bottom of a phrase in French that says the parties have elected that this agreement's drafted in English, and that that used to get around any issues that we'd have about the employee not understanding the implications of an English contract. What does Bill 96 say to employers about that practice?
Yeah, thanks, Tim. Yeah, that's a question that we're actually getting a lot. Especially in the context where our clients are excited, they want to hire a very good candidate, and they say we want to get this offer out for tomorrow. We have this template, we have this language. Is this enough considering Bill 96? The answer to that is actually no. Unfortunately, it's no longer compliant with the Charter of French language. So that means for employers, I would definitely recommend that you have a template available in French and English. So when it comes to time to hire someone, you're ready. And just to make sure to have in your template some sort of authorization form so that the employee can confirm which is the binding version of the agreements. Is it the French one or the English one?
I see. So really it's presenting the employee with the two contracts.
Yes, there's no way getting around it.
Okay. And as Pat said, we've given long webinars on Bill 96. So this is just a sampler for you today. I want to go to the Jess's presentation, and we heard Jess talk about, unfortunately, the fact that in common law provinces, so every province besides Quebec, there's a real push by the judiciary to scrutinize employment termination clauses and to a large degree find the smallest comma or the wrong period in the wrong place and throw the clauses out, and then expose the employer to the common law, or vice versa, provide the employee with the common law notice. At the same time, we saw that chart which shows the increase of that we've seen over the years, sort of inexplicably, about common law notice periods. Now we're up to 27, could be 30 next year, could be who knows where it stops. We will be the most expensive MARCO jurisdiction in the world, if not already, in terms of termination. So long story short, in light of all of that, how often should employers review their employment contracts and their termination clauses in particular?
Yeah, so it's a good question, Tim. And I think, with Waxdale, the decision that I touched on earlier, I think it was a shock to many employers. And, the follow-up from that is still going on in terms of employers going back to the drawing board and dealing with all of their employment contracts that they now need to address in terms of the termination without cause and termination for cause provisions. And so in order to deal with that and sort of on an ongoing basis, I think a best practice is really on an annual basis to take a look, see if the case law has changed, see what you can do to address those changes, and maybe tie the new employment agreement to, a bonus process. Because again, remember, when you're making changes to an employment contract, we have to make sure that we're providing sufficient and fresh consideration to address any sort of enforceability argument with respect to the changes that are made. So I think, give or take 1 to 2 years, but, of course, if there's a significant change or shift in the case law, like Waxdale caused, then it may be more frequent. But I think generally speaking, taking a quick look and making sure you're reflecting the case law and your termination provisions on an annual or biannual basis.
Annual or biannual, okay. And we're not going to get into now how you actually do that mechanically, whether you provide notice or whether you give extra compensation. That's a topic for another day. Marco, turning to you now, in Ontario, but I don't believe in other provinces, we have the right to disconnect law. And so maybe you can talk a little bit about that briefly, because we don't have much time, but how does that right to disconnect kind of parlay with the hybrid working environment? How do you get employees to disconnect? How do you know they're disconnecting when they're not in the workplace or at their home or they're at Starbucks working for you?
So it's a good question, Tim. And so right now, just as a background quickly, Ontario is the only province in Canada that currently contemplates mandating a requirement for certain employers that meet a threshold to implement a disconnection policy. But there is no right to disconnect. So that's despite suggestions in the media to the contrary. The requirement for Ontario for a disconnection policy does not actually create a new right to disconnect from work. So really, in terms of how it intersects with working from home or flexible work arrangements, employers ultimately have some broad discretion here. And I would really say that it's no different than the way that employers manage hours of work in a remote work environment or a flexible work arrangement more generally, to kind of ensure that hours of work, meal periods, overtime, all of those thresholds are being managed and where required, provided to the employees.
Right, and speaking about meal periods and rest periods, we see more and more class actions in Canada on employment standards entitlements, and it gets harder and harder to monitor that and manage it from an employer perspective when you don't see the employees in the workplace and you can't kind of articulate what the schedule is.
Yeah, that's exactly right. Like actively taking steps to ensure that you have similar or the same visibility for a remote work arrangement the way you do in office, I think is important, and something that employers should really contemplate from a legal risk, whether it be class action or otherwise.
I think from legal perspective, we're in a bit of a honeymoon period post-COVID in terms of hybrid work and the lack of litigation that's come out of it. I think what we all expect and anticipate over the next couple of years is, as people settle into, as you said, Marco, kind of a more standardized remote, 2 days a week, 3 days a week remote hybrid workplace, we're going to get to see litigation in that area. Employment standards not being complied with, people not taking their lunch breaks, not knowing they should take lunch breaks, even though maybe they're walking the dog, for 2 hours a day while they're at home. We don't know what's going to come out, but there will be some litigation. Mark our words on that. Sort of last question, because we are running out of time. We're just 1 minute over, but I do want to get back to Emily because I still feel bad about asking her that commercial question. So I want to deal with that. Hopefully, Emily, it's a softball from a client potentially, maybe not, but it's an interesting question, which I actually got asked the other day by a client. I'm just going to read it. If an employer in Quebec has employees in other provinces, do they have any requirement to communicate with those employees in English?
If they have requirements, you have a right to communicate with them in English. Is that the question, Tim?
Yeah, I think really the question is, what if the employer resides in Quebec, they have employees in let's say Ontario or BC, how do they communicate with them? Should they use English? Are the laws, the Bill 96 laws, are they applicable to govern the employer's communication with those employees outside of Quebec?
That's a very interesting, tough question, Tim. And as I said in my introductory comment, it's still not clear what is the scope of the application of the bill. But generally, we would think that even if the employee is not domiciled in Quebec and not working from Quebec, because there's a connection with Quebec, that is the place of business of the employer, then this employee could potentially claim that he or she has a right to work in French and to receive communication in French. And I will take an additional step further. There's even a possibility that job postings should also be available in French and not only in English.
Right. And again, not going to get into this, but there's a lot of action federally about language laws and how they're going to interplay with not only the Quebec Bill 96, Bill 13. It's going to be very interesting to see how employers have to address language laws outside of Quebec, whether they're federally regulated employers or whether they're provincially regulated employers, but whether the federal law will apply to employers across Canada and impose further, French language obligations and requirements to protect the language of French across the country. So more of that to come. And there's again, I think yesterday, the day before, there was a passage of one of those bills. So anyway, again, lots of questions. We couldn't answer them all, of course. Thank you for attending. Really appreciate the last hour that you spent with us. I hope you appreciate it. Again, if you have any questions, you can send them to us. Go on our website. We do have webinars regularly, not just with Mondac, but we do have a series of webinars. We have conferences. Happy to put you on those lists if you'd like. And I know there's a question about how do you get a copy of our book. We'll send that information out when we send you the update after this webinar. So thank you very much. Appreciate your time. Have a great morning, rest of the morning or afternoon or evening, wherever you reside. Thank you very much.